We're now going to move to the vote. The question, therefore,
Mr. Chairman.
This had to be a substantial...
It's a motion.
A motion?
Mr. Chairman, I move that the Speaker be recalled to rule on the issue of the treatment of opposition amendments during this particular piece of legislation.
The question is that the Speaker be recalled. Those in favour will say aye. Contrary, no. Carried. The Speaker will be recalled.
Mr. Chairman.
Mr. Speaker, during the committee stage we have a number of amendments in the name of Steve Chadwick to amend Clause 2. These amendments seek to change the date. They're a whole sequence. They start by moving deletion to 1 July 2010 and start by inserting the words 1 November. The next amendment seeks to insert the word 31 October. We move from 31 October to the 30th to the 29th and 27th, a very good day in October I might add, but 26th and we go on and on through all of those. And in looking at these, we tested the House on the first amendment and the House defeated the amendment. I then ruled that the rest of the amendments were out of order, and I ruled it out of order on the basis of the parliamentary practice by Erskine and May, page 401. Which says an amendment is also out of order if it is inconsistent with amendment already agreed to or if it is substantially the same as an amendment to a motion which has already been negatived. Now, I ruled that the amendment to change the words 31 October was substantially the same as 1 November and in the sequence. The opposition have claimed that I am doing this stopping their right to move amendments. I don't think I am at all. The opposition members are still free to move their amendments. And I think the ruling that I've made is consistent with previous Speaker's rulings. The other matter that's made by the Honourable Trevor Mallard is in actual fact the House has not had the opportunity to test the date. My response to him on that was the House has already seen this legislation at its first reading. It has been to the Select Committee, which has also considered the matter of the date. The bill has come back for its second reading, and the House has passed it on all three occasions. So in doing so, the House has determined that the legislation in general, including the date, is suitable. In my opinion, the House has the ability to consider these amendments, and I would have thought that if a member had an amendment to make to the date, that there would have been quite a substantial amount of discussion about it during the rest of the committee stage, because points and parts of the legislation turned on this. I did not hear that. I would have thought if there was to be an amendment to the date, it would have been there would have been a range of arguments which said that the change to the date was substantially important because of these reasons. I did not hear that. I felt that the House was being tested piece by piece and that there was no substantial difference between one amendment and the next one. And I have accordingly ruled the amendment out. I may wish to come back to you with some other comments later, but that's in essence the situation I understand it. And I'm sure you'll hear from both the opposition and the government members as their views on it.
Thank you, Mr. Chairman. The Honourable Darren Hughes.
Mr. Speaker, thank you for returning to rule on this matter. It's an area of incredible opposition disappointment about the treatment of opposition amendments to this particular legislation, and it falls into two areas, but it's based on the idea that the only ability that an opposition has to rely on through our standing orders and speakers' rulings is the ability to make speeches in opposition to legislation, or to propose amendments to offer alternatives to the committee or to the House, but in this case to the committee in respect of legislation before the committee. And those taken to their extraordinary extent could see the Parliament, as both the Chairman and the Leader of the House have said while we were debating this previously, could see Parliament ground to a halt. But that doesn't happen because although the rules might allow for an enormous amount of material to come by way of amendment or points of order, seeking leave to table documents, for example, those things do not happen because there is a relationship between government and opposition that enables the smooth passage of legislation within reason. Occasionally, sir, that does not exist, and then the opposition has to use what is available to it in order to make its point. For example, if there is an inability to ask ministers questions at question time, the opposition has to use its only tools, which are protected in its speakers' rulings and standing orders, and for which you, sir, have a responsibility as the protector of the minority in your position as Speaker. Now, sir, I know that you made comment at the end of last year about the number of amendments on a particular piece of legislation, but that was within the context of bills never having been seen before by the opposition, the extended use of urgency, things that impacted from a wide variety of angles on the proceedings and good management of the House, either by actions from the government or actions from the opposition that impacted on that. The two points, sir, is firstly around the issue of the use of the government of the standing order for fiscal aggregates. Sir, there was a discussion earlier on, which I want to just briefly bring you up to date with, about whether or not...
Order. I just want to urge the member to stay focused on... I haven't yet actually heard the particular point of order that I've been recalled to rule on, and fiscal aggregates is not the matter that I understand has currently been the matter of procedure that's been delaying the House, and I'd urge the member to focus on the issue of order that he wishes me to rule on.
Sure, thank you, sir. Well, I'm sorry, that will be a matter we do wish to take up with you quite genuinely about amendments, but let me come to the matter for which you have been recalled, and it's the ruling out of amendments which of themselves are in order and which have been submitted by members, in this case the Honourable Steve Chadwick and Moana Maki, and for which after the first vote on the first amendment, the Chairman then moved to rule out all subsequent amendments, and there's an argument about whether they are substantially different or not. I know Mr Mallard has a view about that, but sir, the reason that I wanted you to be recalled is that it is our view that amendments must stand on their own merits, that the ability for an opposition to put forward amendments, that amendment itself should be judged regardless of what other environmental factors are going on that day with regard to how many amendments there are. An amendment must be considered by the committee regardless of how many other amendments that there are. And if I give you an example of that, sir, a very recent example from the 13th of March 2007 on the Child Discipline Bill, sir, there were amendments to change the commencement date once that bill received its third reading, its royal assent, what day it would become law, and there were many amendments that shifted out the number of by a number of months when that would come into law, and all of those amendments, sir, were accepted by the Clerk's office and were put to the House. It's all available there in the journals of the House, and the only time that where that was interrupted was when the government chose to support one of the amendments in order so that the other ones became inconsequential because there had been a decision by the committee. So the Committee of the Whole has faced exactly this sort of situation before, and it has upheld the process of its rules to allow the opposition to be able to take those amendments through. So, sir, our argument is that if these are simply wiped out because they're considered to be similar, it takes away a right of the opposition to signal its disagreement with legislation. But also, sir, in a position where the government is a minority, the Chair cannot possibly know whether or not there is, further down the amendment list, whether or not there is a majority for a different date. And I guess that's where Mr Mallard will comment on the substantially different argument, because in these amendments there are differences which spread over many years. And it may well be, sir, that in a position where the government's in a minority, as it has been since 1998, that there would be